History loves the terrifying spectacle of a paper tiger. We are taught to look at the ancient world through a lens of pure, unadulterated violence, to map the rise and fall of civilizations by the movement of their armies, the clash of their iron, and the sudden, catastrophic destruction of their capitals. A paper tiger state looks monstrous on a map. It boasts millions of subjects, glittering palaces, and undefeated legions. But it is fundamentally hollow. The moment its outer military shield is pierced on a single disastrous battlefield, the entire top-heavy structure shatters into dust. Ancient Rome was backed by iron, but it was not a paper tiger. It was something far more terrifying, far more resilient, and infinitely more elegant.
When 3 elite Roman legions were completely annihilated in the freezing mud of the Teutoburg forest, the empire did not collapse. When Hannibal Barca slaughtered 70,000 Roman soldiers in a single afternoon at Cannae, the Italian countryside did not fracture. Why? Because the true architecture of Roman global dominance didn't exist on the edge of a sword. It existed on the surface of papyrus scrolls, wax tablets, and bronze sheets. The Romans understood a fundamental truth that modern superpowers often forget. You can conquer a territory with iron, but you can only run a continent with a system. That system was just Roman civil law. While the surrounding world relied on the arbitrary whims of tribal warlords or the unstable decrees of absolute monarchs, the Roman mind constructed a massive, predictable, and clinical bureaucratic machine. They didn't just build roads and aqueducts. They built an invisible infrastructure of abstract legal concepts. Long before the first brick of the Colosseum was laid, Roman jurists were busy inventing the foundational building blocks of the modern world. They engineered the presumptio innocentiae, the revolutionary concept that a man is presumed innocent until proven guilty. They drafted the laws of Pacta Sunt Servanda, the absolute, sacred, binding nature of contract. They created the earliest frameworks of corporate liability, property protection, and multi-tiered citizenship.
These ideas were so structurally immortal, so mathematically elegant, that they outlasted the very empire that birthed them. The marble temples of the Forum have crumbled, the aqueducts are broken, and the legends have turned to ash. But if you walk into a corporate skyscraper in New York, London, or Tokyo today, you are walking through a space entirely governed by the genetic code of Roman jurisprudence. Our international shipping lanes, our corporate mergers, our property deeds, and our constitutional rights are still dictated by the definitions carved into bronze by ancient Roman lawyers over 2,000 years ago. This is not a story about bloody battles or mad emperors. It is a forensic minute-by-minute investigation into the most successful administrative hack in human history. Over the next 5 chapters, we will deconstruct the master blueprint of the paper empire. To truly understand how a primitive, mud-walled settlement of cattle thieves transformed into a global superpower, you have to realize that early Rome was a terrifying, hyper-rigid dystopia. And the weapon used to terrorize the population wasn't the sword, it was an invisible, unwritten law.
In the 5th century BC, the infant Roman Republic was trapped in a state of permanent internal Cold War known as the conflict of the orders. The state was sharply divided into 2 distinct castes. On one side were the patricians, the old money, land-owning aristocratic elites who held an absolute monopoly on the military, the treasury, and most importantly, the priesthood. On the other side were the plebeians, the working-class mass of farmers, artisans, and foot soldiers who kept the economy moving and filled the ranks of the infant army. The ultimate weapon of the patrician elite wasn't their wealth. It was their monopoly on knowledge. In early Rome, there were no public law books, no statutes, and no written codes. The legal traditions were unwritten, passed down via word of mouth, and memorized entirely by patrician pontiffs behind closed doors. To the plebeians, the law was a dark, unpredictable magic trick. If a poor plebeian farmer was cheated by a wealthy patrician landlord, there was no text to consult. The plebeian would enter the tribunal, and the patrician magistrate, acting as judge, jury, and executioner, would simply consult his own secret memory or claim that the gods had dictated a specific outcome. Inevitably, the judge ruled in favor of his fellow aristocrat. The ancient historian Livy paints a vivid, heartbreaking portrait of how this arbitrary system worked in practice. He records the story of an old, decorated Roman military veteran who suddenly rushed into the Roman Forum. The man was covered in filth, his clothes were ragged, and his pale skin was completely emaciated. Yet, when he bared his chest, the crowd saw the deep scars of honorable wounds he had received while fighting for Rome against the Sabines. The crowd gathered around him in shock, demanding to know what had happened to a hero of the Republic. The veteran explained that while he was away on campaign bleeding for his country, enemy raiders had burned his farmhouse, stolen his cattle, and destroyed his crops. To pay his state taxes, he was forced to take out a loan from a wealthy patrician lender. But when a bad harvest hit, he couldn't repay the debt. Under the unwritten legal customs of the time, the patrician lender didn't just seize the man's land. He invoked a terrifying, absolute legal mechanism called nexum, a debt contract where a citizen literally pledged their own physical body as collateral. Because the veteran couldn't pay, the patrician creditor legally dragged the war hero away, locked him in a private subterranean dungeon, and brutally whipped his back until it was a mass of open sores. Livy writes that the veteran showed the crowd the fresh, bloody stripes of the creditor's lash on his back, sitting right alongside the scars of the enemy's spears on his chest. The forum erupted into total, unhinged fury. The working class realized a devastating truth. The law wasn't a shield to protect them. It was a weaponized, invisible cage used by the elite to systematically reduce the free population to a status of permanent debt slavery. By 494 BC, the plebeians reached their absolute breaking point. They realized that their physical labor and their blood were the only things keeping the Republic alive. While a massive, hostile enemy army was actively marching toward the city gates, the plebeians executed the ancient world's first documented general labor strike, the Cessatio Plebis. They didn't riot, and they didn't launch a bloody civil war. Instead, thousands of plebeian soldiers simply turned around, walked out of the city walls in perfect, chilling military formation, and set up a massive, armed camp on a nearby sacred mount. They looked back at the empty palaces of Rome and delivered a cold, devastating ultimatum. If you will not give us a predictable, transparent, and written legal system, you can fight your own wars, harvest your own wheat, and guard your own walls. We are leaving Rome to rot. The patricians completely panicked. Without the plebeian muscle, the city was a defenseless target waiting to be slaughtered. The aristocrats blinked first. They surrendered, agreeing to appoint a special 10-man committee known as the Decemviri to strip the legal monopoly away from the priesthood and write down the foundational laws of Rome for the entire world to see. The result of this radical class warfare was the Lex Duodecim Tabularum, the laws of the 12 tables. In 450 BC, these 12 massive bronze tablets were physically erected in the absolute center of the Roman Forum, bolted onto the speaker's rostra for every citizen to read.
The 12 tables were not gentle or enlightened by modern standards. They were a raw, gritty, and deeply shocking reflection of a brutal, survivalist agrarian society. Table 1 laid down the absolute procedural rigidity of the state, stating unabile, stating with cold precision: if a man is summoned to court, he must go. If he does not go, let witnesses be called, and then let him be seized. If the defendant was elderly or sick, the law did not excuse him. The plaintiff was legally obligated to provide a beast of burden or a basic carriage to haul the sick man to the judge. Table 4 contained the brutal, patriarchal reality of the Roman family code, establishing patria potestas, the absolute legal power of a father over his children. Under this law, a Roman father held the literal power of life and death, jus vitae nequisque, over his household. If an infant was born with a visible deformity, Table 4 stated it must be put to death immediately. A father could legally sell his own son into hard labor. However, the law did include a bizarre loophole. If a father sold his son into slavery 3 separate times, the son was finally legally freed from his father's absolute grip. Table 8 dealt with physical injuries and crimes with an uncompromising eye-for-an-eye brutality known as lex talionis. The text stated, "If a person has shattered the limb of another, unless he makes peace with him, let there be retaliation in kind. If you broke a free man's bone with a club, you owed him a massive fine of 300 copper coins. If you broke the bone of a slave, the price dropped to 150. If you were caught stealing crops by night, you were instantly hanged as a sacrifice to the goddess Ceres." Yet, beneath this harsh, primitive exterior lay a revolutionary legal technology that would completely reshape human history. The principle of absolute legal transparency and procedural uniformity. Unlike the ancient codes of Babylon or Egypt, which were carved as immutable commands handed down by gods to absolute kings, the 12 tables were something entirely new. A secular contract hammered out between 2 warring social classes. It didn't rely on divine myth, it relied on human procedure. Rome didn't just invent rules, they invented the legal mechanics to fight them. A patrician judge could no longer invent a rule on the spot to save his wealthy cousin, because the plebeian could walk directly up to the bronze tablets in the middle of the crowded forum, point his finger at the carved text, and demand his rights under the literal code. The text introduced the world to the monumental concept of privilegia nei roganto, the explicit statute that no special laws could be enacted against private individuals. The law had to apply equally to the highest patrician consul and the lowest plebeian farmer. It also established this strict rule that the final decision of the public assembly was the supreme, unalterable law of the land, removing power from hidden private chambers and placing it squarely in the public sphere.
This cultural obsession with the written word became the structural backbone of the entire empire. Roman children didn't just learn poetry or philosophy. The philosopher Cicero records that as late as the 1st century BC, every single schoolchild in Rome was forced to memorize the entire text of the 12 tables by heart as a mandatory, grueling rite of passage into adulthood and citizenship. They were taught to view the rigid, written text not as a set of annoying restrictions, but as the literal definition of their freedom. What is truly mind-blowing is how these ancient, bronze-carved concepts actively dictate the functioning of our modern high-tech society today.
When you look at the bedrock of modern constitutional law, you are looking directly at Table 9 of the 12 tables. Our modern global concept of equality under the law, the idea that a billionaire tech CEO and a minimum wage worker must face the exact same written penal code in a courtroom, is the direct evolution of privilegia nei roganto. Furthermore, our contemporary obsession with due process, the mandatory legal rule that a government cannot just lock you in a room without a formal, transparent sequence of hearings, filings, and summonses, traces its genetic lineage straight back to Table 1's meticulous instructions on how to legally bring a defendant to court.
Even our modern corporate landscape relies on the Roman evolution of these tables. The concept of a written, binding contract that cannot be altered by the arbitrary whim of a massive corporation or a corrupt politician stems directly from the Roman principle of Pacta Sunt Servanda. Agreements must be kept, which found its earliest, primitive roots in the property and transaction codes of the tables. By forcing the elite aristocracy to commit their power to bronze sheets in the mud of the forum, the Roman working class had inadvertently invented the rule of law. They proved that an empire cannot achieve long-term, global stability if the rules are kept hidden in the minds of the powerful. The 12 Tables laid down the concrete, unshakable foundation for the paper empire. An empire where the written word was ultimate, where legal procedure was a sacred religion, and where an ancient bureaucrat holding a papyrus scroll could command far more absolute authority than a general wielding an iron sword. If you want to watch a great empire commit demographic suicide, look at ancient Athens. The Athenians were brilliant philosophers, legendary artists, and fierce warriors, but they possessed a fatal structural flaw, an obsessive, purist arrogance regarding their own bloodlines. Under the strict laws championed by Pericles, to be an Athenian citizen, both of your parents had to be free-born Athenians. If Athens conquered a neighboring city-state, those people were permanently categorized as subjugated, second-class subjects. Foreigners, known as metex, could live in Athens for generations, pay heavy taxes, and fight bravely in the phalanx, but they could never, under any circumstances, become legally Athenian.
As a result, when Athens faced a prolonged military crisis like the Peloponnesian War, they simply ran out of men. Their citizen pool was a stagnant, shrinking puddle. When their soldiers died in battle, there was no legal mechanism to replace them, leaving them to rely on expensive, disloyal mercenaries. Their empire collapsed because their definition of identity was a closed, unyielding wall. Rome looked at the world very differently. The Romans were not genetic purists. They were administrative engineers. They recognized that blood is a finite resource, but the law is infinitely scalable. While the rest of the ancient world viewed citizenship as a matter of sacred ancestry and tribal purity, the Roman mind turned it into something entirely revolutionary: a multi-tiered legal franchise, an abstract contract that could be expanded across continents. They invented the concept of civitas, a legal status that could be bought with silver, earned through decades of grueling military service, granted by political decree to entire territories, or even gifted to freed slaves. Rome realized that the most effective way to permanently neutralize an enemy wasn't to slaughter them, it was to legally assimilate them. The ultimate manifestation of this strategy can be seen in how Rome handled its conquered territories. Through a legal hierarchy known as the Latin Rite, Jus Lati, and the creation of multi-tiered citizenship. When a Roman legion marched into a new territory, whether in the rugged hills of Samnium, the muddy plains of Gaul, or the wealthy coastal cities of Spain, the military conquest was only the brief, volatile first phase. The real, permanent work of conquest began when the jurists arrived with the citizenship ledgers and surveyor tools. Instead of reducing every conquered person to a uniform mass of chained slaves or hostile subjects, Roman law broke the conquered population down into precise, hyper-calculated legal categories, treating citizenship like a ladder that any provincial could climb if they played by Rome's rule. Some cities were granted the status of civitas sine suffragio citizenship, without the right to vote. To a modern observer, this sounds like a raw deal. But in the ancient world, it was a brilliant administrative halfway house. If you were a resident of a city with this status, you were legally obligated to pay taxes to Rome and serve in the auxiliary units of the Roman military. But in exchange, you received full, absolute protection under Roman civil law.
This meant that if a local tribal chieftain in Spain or Gaul tried to arbitrarily seize your land, steal your cattle, or execute your son without a trial, you could bypass him entirely. You could appeal directly to a traveling Roman magistrate. You had the right to enter into legally binding commercial contracts with Roman citizens, just commertii, knowing the courts would violently enforce your business agreements. Furthermore, your marriage to a Roman citizen was fully recognized as lawful, just connubii, meaning your children would inherit your property automatically under Roman inheritance laws. To the conquered elites of the ancient world, this was an intoxicating, irresistible proposition. The ancient Greek historian Polybius, who lived in Rome as a political hostage turned admirer, observed a fascinating psychological shift that occurred across the Mediterranean. When local aristocrats in conquered territories realized that the Roman legal system would protect their private property, enforce their business contracts against their own domestic rivals, and offer their children a pathway to absolute global power, their loyalty shifted overnight. They stopped plotting bloody rebellions to overthrow Rome, and instead started competing with one another to see who could become more Roman. The law acted as a highly sophisticated assimilation virus. A tribal leader in Gaul would spend his wealth to learn Latin, adopt the heavy wool toga, and fund public amphitheaters in his home city, all for the ultimate legal prize, transitioning his family from second-class provincials to full, card-carrying Roman citizens with complete voting and political rights, civitas optimus jur. The sheer, unprecedented shock of this system, and the bitter elite resistance it sometimes provoked, is best illustrated by a famous anecdote recorded by the Roman historian Tacitus, detailing an explosive political showdown that occurred in the year 48 AD during the reign of Emperor Claudius. A delegation of wealthy, highly Romanized chieftains from long-haired Gaul, the very territory that Julius Caesar had brutally conquered a century earlier through a campaign that killed over 1 million Gauls, petitioned the Roman government for the ultimate promotion. They didn't just want citizenship for their people. They wanted the legal right to hold high public office in Rome, climb the political ladder, cursus honorum, and sit as senators in the Curia. The old guard Roman senators were absolutely outraged. They flooded the imperial palace, furious that the literal descendants of the barbarians who had once sacked Rome, burnt their ancestral homes, and slaughtered Roman legions were now asking to sit in the sacred leather seats of Cicero and Cato. They argued that it would degrade the dignity of the Republic, declaring that the wealth of Gaul would swallow Rome whole and push native-born Romans out of their own government. Emperor Claudius walked into the Senate House, faced the angry aristocrats, and delivered a speech that perfectly encapsulates the entire philosophical engine of the Paper Empire. He looked at the traditionalists and told them their xenophobia was bad mathematics. He reminded them of the fatal mistake of Athens and Sparta, stating, "What else proved fatal to the Spartans and Athenians, for all their military strength, but their policy of holding those they conquered at arm's length as foreigners? Our founder, Romulus, on the other hand, was so wise that he fought many peoples as enemies and then adopted them as fellow citizens on the very same day." Claudius pointed out that some of the most noble, ancient families currently sitting in the Senate House had originally come from Sabine, Etruscan, or Lucanian bloodlines that Rome had beaten in bloody battles centuries ago. He asked a devastating rhetorical question. If we integrated the Italians, why should we stop at the Alps? If a man bleeds for the empire, pays taxes to the empire, and knows our laws, his bloodline is irrelevant. Claudius won the debate. The citizenship ledger was opened, and the Gallic chieftains were legally inscribed as Roman senators. By expanding the legal franchise, Rome turned the fiercest, most dangerous leaders of its conquered provinces into the very bureaucrats responsible for running, funding, and defending the empire. The sword of Gaul was permanently blunted by the pen of Rome.
This radical legal framework didn't just apply to conquered elites, it was also weaponized at the absolute bottom of society through the legal transformation of slavery. In Greece, a slave was categorized by Aristotle as a living tool, a subhuman entity who, even if freed, remained a stigmatized foreigner forever. In Rome, the law provided a unique legal upgrade called manumissio. When a Roman citizen formally freed a slave, whether through a tax ledger modification, a final will and testament, or a simple touch of a magistrate's rod, a legal miracle occurred. The former slave didn't just become a free person, they instantly became a Roman citizen, specifically a libertus. While they faced certain social restrictions and could not hold high political office, their children were born as full, unrestricted citizens. This meant that Rome possessed an automated demographic engine that constantly turned foreign captives into loyal, tax-paying, legal stakeholders of the state.
What makes this multi-tiered franchise so distinctively powerful is how its structural architecture directly echoes the design of our modern, hyper-connected global society. When you look at the complex governance of the European Union, you're looking at a direct, modern resurrection of jus laicii. A citizen of France or Germany can move across national borders, purchase private property in Spain, enter into legally binding corporate contracts in Italy, and enjoy full civil protections across an entire continent without losing their distinct local nationality. The EU framework separates local ethnicity from continental legal rights, in the exact same manner that the Roman jurists separated a person's biological Celtic or Iberian origin from their status in the imperial ledger. Even the immigration, labor, and economic frameworks of modern superpowers like the United States rely heavily on this Roman blueprint. The contemporary concept of the green card, permanent residency, is the direct structural equivalent of civitas in suffragio. It is a multi-tiered legal franchise designed to attract global talent, labor, and wealth. It grants foreigners full commercial protection, contract enforcement, and property rights within the state, requiring them to pay taxes and contribute to the economic engine, while withholding the ultimate political right to vote until they pass a formal process of full naturalization. By decoupling identity from blood and turning citizenship into an elegant, scalable legal software package, the Roman mind solved the ultimate riddle of imperialism. They proved that you do not need to maintain a soldier on every single street corner to hold a massive, multi-ethnic territory together. If you give a conquered people access to a predictable, sophisticated legal ledger that violently protects their economic rights and social mobility, they will police themselves. Rome didn't just build a multinational empire that lasted 1,000 years. They engineered a system where the conquered populations eventually became the very iron shield protecting the paper empire from the outside world. Imagine launching a commercial enterprise across a fractured, lawless world. You are a merchant in the 1st century BC based in Alexandria, Egypt. You want to ship 500 amphorae of valuable red wine and 30 tons of grain to a buyer located in the cold, rain-slicked port of Londinium in Roman Britain, thousands of miles away. In any other ancient era, this transaction would be a suicidal gamble. To get your goods to market, your cargo must pass through dozens of different tribal territories, petty kingdoms, and independent city-states. If a storm forces your ship into a harbor in Greece, a local warlord might simply seize your cargo under his own domestic customs. If your British buyer receives the wine and simply refuses to pay you, you have no recourse. You cannot drag a Briton before an Egyptian priest. Without a universal, predictable framework to govern human greed, international trade over vast distances is completely impossible. The risk is too high, the trust is too low, and the transaction costs will destroy your profit margins.
The Romans solved this global paralysis not with an army, but with an unprecedented, abstract legal technology, jus gentium, the law of nations. In the early days of the Republic, Roman civil law, or jus civile, was strictly reserved for full Roman citizens. If a foreigner stepped into the forum, they had zero legal standing. But as Rome's military hegemony swallowed the Mediterranean, the city was suddenly flooded with thousands of Greek, Syrian, Jewish, and Spanish merchants. The Roman Senate realized that if they forced these international traders to operate under rigid, archaic Roman religious oaths, commerce would grind to a halt. They needed a parallel, fluid, and highly pragmatic legal system that could govern transactions between anyone, regardless of their ethnicity, language, or citizenship status. To manage this economic explosion, Rome created a powerful new judicial office in 242 BC, the Praetor Peregrinus, or the foreign magistrate. The foreign magistrate did not care about ancestral bloodlines or religious taboos. His sole job was to keep the gears of international capitalism turning smoothly. He sat in a bustling, high-stakes tribunal and stripped away the cultural baggage of law, extracting the universal principles of human commerce that made sense to every merchant from Carthage to Babylon. The crowning achievement of this court was the legal consecration of the absolute binding power of a mutual agreement, encapsulated in the immortal legal maxim, Pacta Sunt Servanda, agreements must be kept. Under Jus Gentium, but the Roman court system abandoned the primitive need for theatrical verbal formulas or rigid ritual oaths. Instead, they invented the concept of consensual contracts. The moment two parties, whether a Roman patrician and a Syrian silk merchant, or an Iberian miner and a Greek ship captain, shook hands and agreed on a price and a product, a legally binding contract was instantly born, based entirely on Bona Fides, or good faith. If you signed a contract called emptio venditio, a contract of sale, the law did not care if you were a citizen or a barbarian. The Roman state guaranteed that if you paid the money, the seller was legally compelled to deliver the goods. If the seller delivered defective merchandise, if your 500 amphorae of wine turned out to be sour vinegar, the Roman court provided an explicit legal remedy called the actio redibitoria, allowing the buyer to completely rescind the contract, force a full refund, and sue for damages. To see how cutthroat and deeply forensic this ancient corporate infrastructure was in practice, we have to look at the terrifying world of Roman maritime law and shipping fraud.
The Mediterranean Sea was the literal highway of the paper empire, but shipping was an incredibly dangerous business. Ships sank in sudden gales, pirates raided cargo holds, and dishonest captains were notorious for intentionally scuttling old, rotten vessels to pocket their investors' cash. To manage the immense financial risks of global shipping, Roman jurists adopted and codified a legendary set of customary maritime laws from the island of Rhodes, known as the Lex Rhodia de Jactu, the Rhodian Law of Jettison. The Lex Rhodia was an incredibly elegant piece of risk management software. It stated that if a cargo ship was caught in a violent storm, and the captain was forced to intentionally throw half of your valuable grain cargo overboard into the sea to lighten the vessel and save the ship from sinking, you did not have to bear that crippling financial loss alone.
Under the Roman enforcement of the Lex Rhodia, a principle of equitable contribution was automatically triggered. Even though your specific grain was the physical item thrown into the ocean, all the other merchants who had cargo safely remaining on that ship, along with the ship owner themselves, were legally obligated to pay a proportional percentage of their own profits to compensate you for your loss. The law viewed the preservation of the ship as a joint venture partnership, societas. It spread the risk across the entire network of capitalism, giving investors the confidence to fund massive fleets, because they knew the law would protect them from catastrophic single-point failures. But where there is sophisticated insurance law, there is inevitable insurance fraud. The Roman historian Livy records a massive, scandalous criminal trial from the 3rd century BC, involving a wealthy, powerful Roman tax farming and shipping magnate named Postumius of Pyrgi.
During the Second Punic War, Rome's armies in Spain desperately needed supplies. The state was broke, so they hired private corporate entities, known as publicani, the ancient world's first joint stock corporations, to ship clothing and grain to the legions on credit. To incentivize these corporate contractors, the Roman Senate agreed to bear all financial risks associated with storms or enemy attacks. Postumius realized that this legal guarantee was a license to print money through systematic fraud. He purchased worthless, decayed old hulls, loaded them with cheap, rotten rags and small amounts of spoiled grain, and sent them out to sea. He then ordered his captains to intentionally ram the ships into rocks or scuttle them in shallow waters. Postumius would then rush into the Roman courts, weeping over his tragic losses, and demand massive, top-dollar insurance payouts from the state treasury for the luxury supplies he claimed had sunk. He got away with it for years, accumulating vast wealth, until a forensic audit by Roman investigators revealed a glaring pattern. Postumius's ships only seemed to sink when they were carrying state-insured cargo, while his private, uninsured commercial voyages always arrived perfectly intact. The case was brought before the public assembly. Despite Postumius attempting to hire thugs to riot and disrupt the tribunal, the Roman people voted to heavily fine and banish him from the Republic. The law proved that even in the chaotic fog of a total world war, the state's legal framework would aggressively hunt down corporate malpractice to protect the integrity of the marketplace. What is truly jaw-dropping is how these specific 2,000-year-old frameworks of Gentium and Lex Rhodia directly govern our modern global economy. If you look at modern international shipping law today, the legal rules that dictate what happens when a massive container ship catches fire or gets stuck in the Suez Canal. The maritime courts still utilize an identical legal principle known as general average. When a modern captain throws cargo overboard to save a container vessel, modern maritime lawyers sit in corporate offices in London or Singapore and calculate the payouts using the exact same mathematical formulas laid down by the Roman IV magistrate under the Lex Rhodia. Furthermore, our entire contemporary system of global supply chains and international contract law is the direct ideological descendant of Justinian. When an American tech firm purchases microchips from a manufacturer in Taiwan, they do not rely on local religious traditions or arbitrary tribal customs. They sign a contract governed by the UN Convention on Contracts for the International Sale of Goods, CISG.
The Convention on Contracts for the International Sale of Goods is at its core a direct translation of Bona Fides and Pacta Sunt Servanda. It operates on the exact Roman premise that commerce must be secular, predictable, and uniform across borders, providing standardized remedies for defective goods that look identical to the ancient Actio Redibitoria. By inventing a universal non-ethnic code of contracts, the Roman mind did something far more permanent than conquering territory. They built an interconnected global marketplace. They proved that if you create a legal system that violently enforces the agreements made between strangers, the world will beat a path to your door to trade. Long after the Roman legends left their outposts, the universal legal mechanics of Roman capitalism remained, forming the invisible, unyielding connective tissue that still binds the modern corporate world together today.
Conquest is a messy, chaotic, and inherently bloody business. When a military superpower invades a vast territory, defeats its tribal armies on the battlefield, and claims the soil as its own sovereign prize, it immediately faces a logistical and political nightmare of apocalyptic proportions. Who actually owns the dirt beneath the soldiers' boots? How do you stop 1,000 furious, battle-hardened, and heavily armed legions of veterans from slaughtering each other over border disputes when they are discharged? How do you prevent the conquered population from launching a permanent, multi-generational guerrilla insurgency because their ancestral family farms and sacred burial grounds were stolen without a paper trail? The surrounding ancient world answered these chaotic questions with raw, disorganized, and highly unstable violence. Conquered land was treated merely as the wild spoils of war, thrown arbitrarily to favorite generals, consumed by corrupt royal courts, or left in a state of permanent, lawless friction that invited constant civil conflict.
Rome took a look at this structural chaos and brought out the surveyor's brass cross, the groma, the measuring cords, and the heavy leather property ledger. They realized a profound truth that modern nation builders often miss. If you want to permanently pacify a conquered continent, you'd don't just station a permanent legion there, you legally, systematically map every single square inch of it. They invented Centuriation, the systematic geometric transformation of wild, untamed, and conquered landscapes into a hyper-regulated legal grid of private property.
When a Roman legion finished its bloody work and marched out of a newly broken region, the military commanders stepped aside and the agrimensors, the Roman legal land surveyors, literally meaning measurers of fields, stepped forward. These men were not mere map makers. They were high-ranking civil servants possessing the status of legal magistrates.
Armed with their precise geometric alignment instruments, these surveyors climbed the highest hill in the territory and cut two massive, intersecting perpendicular axes directly through the virgin landscape. The Decumanus Maximus, running precisely from east to west, and the Cardo Maximus, running from north to south. From that single absolute crosshair, they carved the entire territory across forests, rivers, mountains, and marshes into perfect, uniform squares called centuriae, measuring roughly 200 Roman acres each.
Every single one of these massive squares was physically marked on the ground with heavy stone boundary markers called termini, which were consecrated with religious sacrifices to the god Terminus, the deity of boundaries. To move a boundary stone was considered a capital crime. The perpetrator was declared caesar, accused of sacrilege, legally stripped of all civil rights. It could be executed by anyone on site without a trial. Every single plot carved by the surveyors was meticulously inscribed into an imperial bronze map called a forma. This bronze map was duplicated with absolute bureaucratic precision. One copy was permanently displayed in the local provincial administrative building for public inspection, and the master copy was wrapped in linen, sealed, and shipped straight back across the sea to the state treasury, the aerarium, inside the Temple of Saturn in Rome.
But this massive engineering feat wasn't just an exercise in cartography or geometry, it was the physical deployment of a massive weaponized legal framework known as Dominium ex jure quiritium, absolute property ownership protected by the full violent majesty of Roman civil law. Under Roman property law, land ownership wasn't a vague shifting concept based on who had the biggest club or the most cousins. It was a mathematically defined absolute right. The law drew an invisible, impenetrable, and sacred wall around a citizen's registered land. If anyone, even a wealthy, politically connected patrician senator with an army of clients, stepped onto your mapped property without explicit legal permission, you didn't have to launch a private blood feud or assemble a militia. You walked into a court and initiated a legal action called a re vindicatio, a heavy-duty lawsuit to reclaim physical possession of an item or land based entirely on absolute legal title.
In the Roman courtroom, the judge did not care about your social status, your wealth, or your family pedigree. He cared about the bronze ledger and the alignment of the surveyor's stones. If your name was written on the forma, the law would deploy the physical violence of the state to evict the trespasser, throw down their illegal fences, and restore your property to you. The sheer unyielding fanaticism with which Roman law protected property lines, even at the expense of its own critical national security, is brilliantly illustrated by an extraordinary, historically verified legal showdown recorded by Cicero, involving a common Roman citizen named Marcus Licinius Crassus, not the billionaire triumvir, but a modest, fiercely independent Italian landowner, and the state's military infrastructure. During a period of intense military crisis, when a foreign invasion threatened the heart of Italy, the Roman army needed to rapidly construct an emergency defensive fortification wall to protect a strategic highway from an impending barbarian incursion. The military engineers drew a straight line across their tactical maps and began digging deep trenches and building massive, timber-reinforced ramparts. However, the path of this vital military wall cut directly through a small, private farm owned by this stubborn native citizen. The army officers on the ground didn't hesitate. They knocked down the farmer's fences, trampled his valuable olive trees, and began erecting the state's fortification wall directly across his property lines. In any other ancient empire, whether in Babylon, Persia, or Egypt, that farmer would have been executed on the spot, beaten into compliance, or locked away for daring to slow down the national war machine. Instead, the farmer walked straight into the courts of Rome and filed a formal property lawsuit against the military magistrates.
He argued that under the civil code, the state had committed an illegal trespass and destroyed his private dominium without a formal legislative decree of expropriation or fair compensation. The case went before a panel of jurists. The military commanders argued that the survival of the state was at risk, that the barbarians were marching, and that the wall was a matter of urgent, undeniable public safety. The jurists looked at the 12 tables, reviewed the property ledgers, and delivered a stunning verdict. The military had broken the law. The court ruled that the state could not arbitrarily violate the private property boundaries of a citizen without a formal, legal act of purchase. The Roman government was legally forced to halt construction on the strategic wall, pay the common farmer a massive financial settlement for the damage done to his olive trees, and formally purchase the strip of land from him at market value before a single additional stone could be laid. The message to the entire Mediterranean world was chillingly clear. Not even the legendary legions of Rome were more powerful than a legally registered property deed.
This rigid defense of property boundaries was the ultimate weapon of pacification. When Rome conquered a territory, they didn't just take all the land for themselves, they often left large portions of it in the hands of the defeated local population, formally registering the locals' ancestral farms directly into the Roman property ledger. By doing this, Rome pulled off a masterful psychological trick. A conquered provincial farmer in Gaul, Spain, or Greece suddenly realized that under Roman rule, his land ownership was safer than it had ever been under his old tribal kings or erratic local warlords. If a corrupt local elite tried to steal his farm, the Roman Revendicatio would step in to protect. The law gave the conquered population a direct, massive financial stake in the stability and survival of the paper empire. They paid their taxes willingly because those taxes funded the legal system that kept their property safe.
What is truly astonishing is how this ancient, geometric property framework actively dictates and underpins our modern capitalist world today. When you look at a modern satellite map of the United States Midwest, Canada, or parts of Australia, and you see those endless, perfect square miles of agricultural grid lines stretching across the continent, you are looking at a direct, literal resurrection of Roman Centuriation. The U.S. Public Land Survey System, created by Thomas Jefferson and implemented across the American frontier, was explicitly and directly modeled after the Roman agrimensor system. It carved the vast American wilderness into uniform, square townships to ensure that every pioneer had an absolute, legally auditable property deed that could prevent internal border wars. Furthermore, our entire contemporary system of real estate, banking, and wealth accumulation relies on the exact genetic code of the Roman Revendicatio. Every single time you buy a house, a condominium, or a piece of commercial land, your bank and your insurance company require a rigorous procedure called a title search and the purchase of title insurance. Modern title companies spend billions of dollars scouring digital county ledgers to trace the exact chain of ownership of a piece of dirt back through decades of history, ensuring that no one else has a hidden claim, an ancient lien, or an unrecorded boundary right to it. This modern legal obsession with clean, public title registries is a direct translation of the Roman forma. It operates on the identical Roman premise that capitalism cannot function and society cannot remain stable unless a landowner can stand on their property and know that the ultimate, violent authority of the state will defend their written boundary lines against the entire world. By turning the wild, contested terrain of the ancient world into an orderly, predictable matrix of legal titles, The Roman mind created an invisible infrastructure that easily outlasted all their concrete monuments. They proved that an empire is not held together by the physical walls it builds on its borders, but by the invisible, unyielding property lines it carves into the minds and ledgers of its people. By the 6th century AD, the Western Roman Empire was a ghost town of vanished authority, fractured into a chaotic mosaic of warring Germanic and barbarian kingdoms. The concrete roads that once bound a continent together were cracking from neglect. The legendary aqueducts were being smashed or falling into disrepair, and the grand marble basilicas of Rome were being actively scavenged for raw building materials. But in the east, within the massive, sea-washed walls of the superpower Constantinople, the Roman flames still burned with blinding intensity. Yet, it was suffocating under the crushing weight of its own administrative success. For over 1,000 years, Roman emperors, praetors, and jurists had been pumping out millions of laws, imperial decrees, local edicts, and legal opinions. The paper empire had created a literal mountain of paper. The legal system had become a chaotic, terrifyingly self-contradicting labyrinth.
The famous contemporary historian Procopius of Caesarea recorded that the sheer volume of legal texts had become completely unmanageable for human minds. There were so many competing statutes, ancient precedents, and overlapping provincial rules that absolutely nobody, not even the most expensive, brilliant advocates in Constantinople, actually knew what the law was anymore. If a corrupt provincial judge wanted to rule in favor of a wealthy criminal or a predatory landlord, he didn't need to break the law. He could simply hire a researcher to dig up a forgotten 500-year-old imperial decree from a long-dead emperor to completely justify his crooked ruling. Justice was agonizingly slow, wildly unpredictable, and deeply corrupt. The legal engine that had built the empire was violently seizing up. A glaring example of this legal paralysis was the law of citations, an emergency measure passed a century earlier that tried to solve court disputes by a literal head count. If two lawyers disagreed on a point of law, the judge was forced to count up how many dead classical legal authorities supported each side. If Gaius and Papinian said one thing, but Ulpian, Modestinus, and Paul said another, the majority won. If the dead authorities were tied, the opinion of Papinian broke the tie. It wasn't justice. It was an archaic, bureaucratic math game that left the state completely paralyzed to deal with modern problems.
Enter Emperor Justinian I. Ascending the throne in 527 AD, Justinian was an outsider, a low-born provincial from the Balkans who had climbed to the absolute peak of autocratic power. Because of his origins, he possessed the pragmatism of a ruthless engineer. Justinian realized a terrifying truth. You cannot rule a global empire if your operating system is fundamentally broken. He knew that the ultimate survival and restoration of Rome didn't just depend on reconquering lost territory with legendary generals like Belisarius. It required a total, forensic purification of the Roman mind.
The modern historians Edward Gibbon famously noted in the history of the decline and fall of the Roman Empire that Justinian saw the codification of the law as a vital act of imperial conquest, an intellectual triumph that would outshine the physical reconquest of Italy and Africa. He sought to replace a jungle of confusion with a temple of geometric order. So actually, to execute this mind-bogglingly ambitious mission, Justinian appointed a brilliant, workaholic, and ruthlessly efficient legal bureaucrat named Tribonian to lead an elite commission of legal scholars, professors, and top-tier practitioners. Their instructions were clear and terrifying: capture every single scrap of Roman law created since the 12 Table Ales, burn away the contradictions, delete the obsolete fluff, and condense the absolute distilled essence of human justice into a single uniform master code.
Tribonian's team worked at a frantic, almost computational pace. reviewing over 3 million lines of legal texts and opinions from centuries past. They slashed away archaic vocabulary, removed pagan religious rituals that no longer applied to a Christian empire, and eliminated hundreds of redundant laws that had protected long-dead institutions.
The result of this monumental intellectual salvage operation was the Corpus Juris Civilis, the body of civil law, universally known to history as the Justinian Code. The Corpus Juris Civilis was divided into distinct interlocking software modules. First was the Codex Justinianus, which gathered and organized all imperial statutes into a single, streamlined, and perfectly indexed reference guide. Second was the Digesta, or Pandects, a massive multi-volume compilation collecting the finest, most brilliant analytical opinions and structural logic of Rome's legendary classical jurists. Third was the Institutiones, a standardized mandatory textbook is explicitly designed for every first-year law student across the civilized world. To ensure that everyone knew the gravity of this new text, Justinian addressed the students in the preface not as mere pupils, but as the youth desirous of law, warning them that their mastery of this book was the only passport to serving the state. To prevent his brand new system from ever becoming corrupted, bloated, or fragmented again, Justinian took a radical, authoritarian step that stunned the legal profession. He legally and totally banned any future lawyers, judges, or professors from writing commentaries, glosses, or personal interpretations on his new code.
Justinian declared that the text was perfect, complete, and perfectly transparent. If a legal professor dared to write a lengthy book explaining what the Justinian Code actually meant, or trying to find a loophole, the book was publicly burned in the city square, and the author was charged with the capital crime of forgery and banished. If a judge faced an ambiguity, they were forbidden from inventing a precedent. They had to appeal directly to the emperor himself for clarification. The operating system was locked down. No unauthorized third-party patches were allowed. The true genius of Justinian's crystallization of Roman law is that it acted as an indestructible, intellectual time capsule. When Constantinople finally fell centuries later, and the Byzantine Empire vanished into history, this dense, highly organized package of distilled Roman logic didn't perish. Instead, a copy of the Digesta was rediscovered in an Italian library in Pisa during the 11th century, hitting the chaotic, feudal medieval world like an intellectual tidal wave. At a time when European kingdoms were relying on primitive trials by ordeal, where an accused man had to plunge his hand in a boiling water or hold a red-hot iron bar to prove his innocence through a miracle, the rediscovered Roman law offered a dazzling, secular system of pure logic, documentary evidence, and professional courtroom procedure. University centers like Bologna were founded specifically to study Tribonian's texts. When Napoleon Bonaparte sought to unify a fractured, post-revolutionary France and destroy the messy patchwork of regional feudal customs, he explicitly turned to the Justinian Code. He used its structural bones to design his legendary Napoleonic Code of 1804. Through Napoleon's global conquests, this Roman operating system was hardwired into the legal, civil, and social DNA of continental Europe, Latin America, Louisiana, and vast portions of Asia. What is truly jaw-dropping is how Justinian's ancient editorial project directly dictates the structural architecture of our modern globalized world. When you look at the deep divide in modern international legal architecture, you are looking at a map drawn by Justinian. The entire framework of civil law, the dominant legal system used today by over 150 nations across the globe, is the direct, unadulterated evolution of the Justinian Code. Unlike the Anglo-American common law system used in Britain and the US, which relies on a messy, evolving web of shifting judge-made precedents and oral traditions, civil law nations operate on the exact Roman premise that the entire law must be completely written down by a sovereign legislature into a single, logical, and universally accessible codebook. Furthermore, The very language of modern law, global power, corporate governance, and academia remains completely captive to the terminology minted by Roman jurists. Every time a modern court issues a subpoena, literally under penalty, references pro bono work for the public good, applies an affidavit, he is stated on oath, or utilizes the concept of habeas corpus, they are speaking the literal tongue of the paper empire. Even the core concepts of your everyday financial and civil life, such as usufruct rights in real estate, the strict distinction between criminal and civil liability, the laws of wills and intestate succession, and the foundational human right that a defendant is innocent until proven guilty, which was formally codified as a universal principle in the Justinian digesta under Title 22, are direct intellectual imports from the desks of Tribonian and his 6th century scholars. By compressing a millennium of legal evolution into a single, portable, and mathematically precise masterwork, the Roman mind achieved true immortality. They proved that concrete monuments will inevitably crumble, bronze triumphal statues will be melted down for weapons, and grand political dynasties will fall to ruin. But a perfectly engineered idea, a system of pure, secular logic that elegantly balances human rights, property boundaries, social contracts, and corporate obligations, is completely indestructible. The legions conquered the ancient Mediterranean for a few centuries through raw military terror, but the written word of Roman law conquered the entire modern world forever. The paper empire never truly died. It simply became the invisible legal scaffolding that holds our global civilization together today. We are taught to believe that empires are built of stone and iron. We look at the ruins of the Colosseum, the towering arches of Spain, and the deep ruts worn into concrete roads, and we think, this is what it means to conquer. But stone fractures, iron rusts. The concrete monuments that Rome left behind are nothing more than beautiful, hollow fossils. The true, terrifying genius of the Roman Empire was never its ability to stack bricks or throw spears. It was its ability to turn the chaotic, violent nature of human greed, ambition, and identity into an abstract, scalable machine. They built an empire out of paper, ink, and code. When the last Roman soldier marched off the frontier, the empire didn't vanish. It simply took off its armor and put on a jurist's robe. Every time you sign a business contract with a stranger across the ocean, buy a piece of land with a guaranteed property title, walk into a courtroom presumed innocent until proven guilty, or cross a continental border with a set of shared civil rights, you are not living in a modern world. You're living in a Roman colony. The legions conquered the ancient Mediterranean for a few centuries, but the paper empire conquered the future forever. The ledger outlived the sword. The code outlived the crown. And long after our own modern skyscrapers have crumbled into dust, the invisible legal architecture of Rome will still be running the world.
If you want to uncover more of these hidden, forgotten, bizarre layers of our global past, make sure to smash the like button, share this video with fellow history enthusiasts, and subscribe. Hit that notification bell so you never miss another deep dive into the strange blueprints that built our modern reality. Leave a comment below with which chapter of Rome's paper infrastructure surprised you the most, and as always, thank you for watching.